Learn how 2 unfavorable functional capacity evaluations gave American General Life a winning claim denial. Did you know that disability insurance carriers often demand objective basis for restrictions and limitations and the policyholder's inability to perform any occupation? Now, an FCE, a functional capacity evaluation, is a great way to prove the policyholder's level of functionality. In my view, in combination with the opinion of a vocational expert, the FCE and the VEs are a 1-2 punch that should overcome a carrier's denial. However, an unfavorable FCE can be the kiss of death. So let me explain to you the case of Lord versus American General Life Insurance Company of Delaware. It's a Georgia case. The plan provided for the payment of benefits for 36 months, and then thereafter the policyholder was entitled to benefits if they were unable to work in any gainful occupation, even on a part-time basis. Pretty tough. Lord had not only 1 but 2 unfavorable FCEs, and as a result American General denied the claim. She appealed, and ultimately the court held that the denial wasn't arbitrary and capricious because, look, those 2 functional capacity evaluations found that Lord could work in a light-duty capacity, and even in a later FCE, the second one, in a sedentary capacity. What was worse was her reports didn't support her inability to perform any occupation. In other words, her medical doctors didn't help her. Now, the clinical nurse manager and the VE providers for American General Life concluded she could do both light and sedentary work. And they had a peer review provider who said, I don't think she has any restrictions and limitations in view of her medical conditions and medication use. But the court upheld the denial, relying on the 2 unfavorable FCEs and the lack of support by her physicians. It was a 1-2 knockout punch for Ms. Lord. If your claim has been denied, I strongly suggest that you consult with an experienced ERISA disability attorney such as myself. One of the tools in my toolbox is to use a functional capacity evaluation to determine and establish my client's physical restrictions and limitations. I then want the treating physician to sign off on them and endorse them as being appropriate and as an objective basis for the restrictions and limitations. Then my second punch is a vocational evaluation, because we want to establish, based on the restrictions and limitations found by the FCE, that the policyholder can't do any other occupation in the national economy or pursuant to the DOT, depending on the definition of any occupation, but that they can't do another occupation based on their education, skills, and those restrictions and limitations. And I also want my VE to attack the carrier's vocational evaluation opinion and use the carrier's own doctor's restrictions and limitations as appropriate to combat the disability carrier's conclusion that there is other work that the policyholder can do and which is the basis of the claims denial. So I want to attack them on a 2-front basis. I want to have the FCE, I want the vocational evaluator, our vocational evaluator, to attack the opinions of the carrier's treating physicians and vocational evaluators, and then I want the vocational evaluator to address my client's ability to perform other work based on the FCE results that we've obtained. To me, that's the 1-2 punch that will help you get the disability benefits you deserve, regardless of where you live in the United States. Call me today at 727-894-3188 for a complimentary consultation.